The first matter on today's calendar is number 109, People versus Charles Smith.
Good afternoon, Your Honors. Claudia Flores, Center for Appellate Litigation for the appellant Charles Smith. I'd like to request 2 minutes of my time for rebuttal.
You may have 2 minutes, Ms. Flores.
Thank you, Your Honor. The trial court in this case should not have completely restricted defense counsel from inquiring about the federal civil rights lawsuits filed against the two officer witnesses. First, the court erred in concluding that the lawsuits had no relevance to the officer's credibility. This is a case where the officer's credibility was a key issue and a close issue. It was a centerpiece of defense counsel's strategy. And all three of...
Did defense counsel make the argument that it was about credibility, or was that a general argument, or did defense counsel make some other arguments?
Yes, Your Honor. The defense counsel explicitly said this goes directly to the officer's credibility, and the trial court responded with this: there's nothing to this that goes to credibility. So the trial court ruled on the grounds that these lawsuits were not relevant to credibility, and that was error. These lawsuits are relevant to credibility, and defense counsel should have not been completely restricted from inquiring about them. The trial court certainly had the discretion to limit the method and the extent of the questioning, but it did not have the discretion to limit...
What could you have asked? What would trial counsel have asked?
Correct. And some of the questions defense counsel may have posed, for example, may not have been the perfect questions to ask, but defense counsel certainly could have asked...
You agree that counsel could not ask, have you been sued?
Correct.
Okay.
Defense counsel could not have asked, have you been sued, should not have asked how much, was this settled for $50,000, but defense counsel certainly could have asked about the underlying acts alleged in the lawsuit. So he could have asked, is it true that you arrested Mr. Ambos or Mr. Logalishi, and actually you had no grounds for that arrest. You actually did not, in fact, witness a drug sale, and yet you went forward with that arrest anyway, even though he had committed no crime.
Well, wouldn't defense counsel have to establish? You can't ask somebody if they have committed a crime, unless they've been since he hasn't been convicted. You can't ask somebody if there's an allegation against them. That would be. So where's the foundation, I guess, is what I'm wondering, to ask these questions. I understand what questions they could ask, but that doesn't establish a foundation to ask the questions.
Correct. The foundation comes out of the lawsuits themselves, and that's where... Well,
okay, so did defense counsel come in and say, these are the lawsuits, put them in the record, put the papers in the record? Did he say that these are the questions that I would be asking regarding these lawsuits to the underlying facts of the lawsuits themselves, to establish a proper foundation, and then from there, outside the presence of the jury, and then from there go forward? Was that done at all?
It was attempted. Defense counsel said, I have federal documents. The court said, do you have them? He said, I do have them. I have one lawsuit that was settled for this amount. I have 2 other lawsuits against the other witness. These are very similar facts.
So your position is, I don't mean to cut you off, just to kind of, because you only have so much time. Yeah. So your position is then that he attempted to establish a foundation and the trial court cut him off?
Correct. He did attempt. He laid out all the necessary information that the trial court needed to know that there was a good faith basis here for questioning. And
so were there answers filed in the lawsuits denying the allegations?
I believe there were.
So he's going to say, he's going to deny, right? Do you expect something else?
He might deny, but the jury should still get to assess his demeanor as part of his credibility. If this isn't something he was expected, he may not be prepared to deny. We don't know. The point is, if this was any other type of witness, not a police officer...
Were you attempting to have the actual documents of the lawsuit submitted into evidence?
No, Your Honor.
Could you?
No, Your Honor.
You ruled in favor of your client. Could you? Would that be the next step?
Not necessarily. Perhaps the record here is not fully developed enough in this case to determine whether this actually would have gone to a material issue at trial, say a scheme by these officers to consistently lie about observation drug sale cases. Then it would have been a really material issue where the extrinsic evidence would have been admissible. But if we're just talking about credibility, about attacking that, no, they shouldn't have introduced you.
As some settlements do, sometimes the party agree basically to a gag order. Could you have asked if that was included in the settlement?
That's a more complicated question. The point is, going back to the trial court's ruling, which is that this wasn't relevant at all, if these had been any other witnesses, if these had not been police witnesses, they could have asked about these allegations, and it wouldn't have mattered where the allegations came from. For example, if I hear, talking about any kind of prosecution...
Counsel, just to interrupt you, but that's not what they were proffering they wanted to ask. I mean, there's a proffer of what this defense counsel wanted to ask, and it goes through the settlement amounts and where the underlying arrest case is dismissed. So what you're asking us to do, I mean, and that's what the judge ruled on. But now you're asking us to look underneath the proffer the defense counsel made that we have a record of and say there might have been facts in an underlying suit that apparently are not part of this record that we have that they could have asked about. And I don't see how we can do that.
Well, the record is not entirely clear. It is a cold record, and it is hard to tell exactly what defense counsel was trying to ask about and what he could have asked about had the court not shut him down. As soon as he introduced the topic, the court said no. And the court said absolutely not. And eventually, after he proposed a line of questioning, said, I will not do this, I'm taking the jury. So we don't know exactly what defense counsel could have asked.
Yes, we do, because he said he was going to ask, were you involved in the arrest of this person? If so, isn't it true that the case you made in an arrest, and you said that this person was guilty of a drug sale, and yet the cases were later dropped? Isn't that a fact? And that's when the court says absolutely not. So do you think that's an appropriate question to ask on cross?
The part about the charges being dismissed is not, but the problem here, so the heart of his question was appropriate. The heart of his question about was, did you participate in this arrest? And wasn't it not true? That's really what he was getting at. Whether he was asking about the dismissal of the charges is sort of a matter of semantics. What he's implying is that because the charges were dismissed, you must have been lying. That wouldn't have been the appropriate way to ask it, the way he was proposing, but it doesn't mean that he shouldn't have gone to ask it a little bit differently.
And
but
then the court said absolutely not, and he said, no, could I, and then the court
Exactly.
shut him down. So we don't
we don't know
no
what
idea what he was
we don't know what he could have said as an alternative. He wasn't given the opportunity to proffer an alternative because the real basis the court denied this request on was relevance. Judge Mullen said that this is absolutely not relevant to credibility. So we don't know how Justice Mullen would have curtailed the questioning or framed it.
Could I take you back to something you started to say, and it goes to something that Judge Fahey raised, whether you need a good faith basis or something else, foundation. What is that you say? Do you have to have a foundation and a good faith basis, or just a good faith basis?
Well, they could be the same thing. I think you only need to have a good faith basis here. Looking to the cases where we look at credibility for any other witnesses, or we look at prior bad acts that are not stemming from civil rights lawsuits, all that counsel has to show is a good faith basis. So, for example, in another context, counsel could have wanted to ask a prosecution witness about an incident of domestic violence. It could have been enough that counsel was told about that incident by the witness's wife. That's a good faith basis. He wouldn't have needed to introduce documents to lay that foundation.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon, Your Honors. May it please the Court, my name is Patricia Kern, and I represent the people on this appeal. First of all, the trial court properly precluded the proposed line of questioning that the defense counsel asked when he wanted to talk to the officers about pending and settled lawsuits.
How do we know what counsel would have asked if the court hadn't interrupted him?
Your Honor, I don't believe the record shows that the court restricted defense counsel from making a full record. If you look at the transcript, you will see that there is a back and forth between defense counsel and the judge for a page and a half, almost 2 pages about this. He wasn't precluded from making any record that he wanted to. If he wanted to put the federal documents that he referenced into marked as an exhibit.
What did he need to have said?
He needed to have said that he wanted to ask about specific prior acts of misconduct by these officers, and he needed to show that in the federal complaints that he referenced but never marked as an exhibit, that he could show the 2 officers at issue here, Zambrano and Latufo, that they were actually charged with, and there were allegations of specific misconduct by them.
So it's not enough to say, I have the pleadings here, this is my, and it says that, this is my good faith basis. It has to be marked into evidence?
Well,
it has to be a formal proffer?
He could have read it into the record, but he certainly had to either read it into the record or show somewhere in the documents, assuming that he was limiting himself to the documents as opposed to other possible good faith bases, that these officers had committed specific acts of misconduct. He never did that.
You mentioned something about pending lawsuits and unsettled lawsuits. Is that the criteria, that something has to be settled or not pending, has to be completed before one can ask a question about misconduct?
No, Your Honor. I think that regardless of whether the lawsuits are pending or settled, that the lawsuits themselves could allege in their documents specific acts of misconduct by the officers. The federal documents that defendant now claims he proffered at trial, though he never made a record of it below, never say that. They just have very general allegations against group of officers. They never allege specific acts of misconduct about the two officer witnesses in this case. It could be that if these lawsuits had continued down the line through discovery and trial or things of that nature, that maybe those lawsuits offered specific acts of
So,
misconduct.
counsel, let's say you've got the complaint. The complaint says, I was standing on the corner listening to music. Officer X, actually names the officer, came up, pushed me up against the wall, and arrested me. He arrested me without probable cause. The charges were dismissed. Is that enough? Do you need more specificity?
That certainly gives the defendant a good faith basis for a specific act. However, I don't think the inquiry is over at that point. The court, the trial court, still has the obligation to weigh the prejudicial value versus the probative value in these cases.
Okay, but you would say that that is specific enough?
It can be.
Aren't you making the arguments that perhaps the court should have made at the time that this was being discussed? In other words, you say, well, in the complaint, there's just general allegations. It never got that far. He's making the motion, and he gets halfway through a sentence saying, and the city settled for a large sum of money, and the court says no.
Well, because, Your Honor, below, defense counsel focused solely on the pending and settled lawsuits.
What's wrong with that? And what I'm saying is, you were saying, well, the lawsuit has general allegations. The judge didn't know that. For all she knew, they could have been specific. She didn't let anybody discuss what was going to be brought in. Isn't that true? I mean, she simply said no.
I disagree with you, Your Honor.
What does no mean? It says, the only other question I have as far as cross-examination is concerned, Your Honor, is there are a number of federal cases against the officers in question for civil rights violations under very similar facts, where they made a narcotics arrest, very similar on the facts, and the case was then dropped by the DA, and the city settled for a large sum of money. Court, no.
But then the record goes on for another page and a half, Your Honor, where they're talking about this.
I understand that, but what I'm saying is you were making arguments that the documents say one thing, the documents say another thing, there could be these allegations. She's saying no.
I disagree that this court restricted this defense counsel from making a fuller record, particularly because he goes on to make a fuller record about why he thinks questions about lawsuits are appropriate.
She says, do you actually have federal documents? He says, absolutely. I have one case for Zambrano, and it's the two cases for Zambrano, two defendants, same actual, and it's, are they pending matters? He says, okay, and then he goes into a good description of them, and then before he gets done, she says, absolutely not, defense, nor could I. The court says, we don't know why the cases were dismissed, we don't know. Well, ask. I mean, what, it seemed clear to me that this judge was not going to allow these in, period. And every time the lawyer wanted to make a record with respect to this, he got a no and absolutely not, and then finally she says, I'm calling the jury and let's go.
But, Your Honor, if he had wanted to talk about why the cases were dismissed, he could have. It's more likely from this record that he didn't have that information.
Well, let's assume for a minute that he did, but we can put that aside. Do you think under any circumstances information such as was being offered here are admissible?
No, because they're only assertions.
Well, so what I'm trying to get at, do you see any way that an officer can be impeached by conduct that predates the case in front of the judge?
Yes, if there are specific factual allegations, not mere accusations that...
Have we allowed accusations to be the good faith basis upon which defense counsel or any counsel can cross-examine a witness on credibility?
You could. The bar for a good faith basis is fairly low, but it also has to be a reasonable basis in fact, but it has to be specific. Here, this lawyer focused totally on pending and settled lawsuits, not about the specific acts that he claimed at least, or he claims now, not below.
But counsel is starting at that point, saying, this is the source of my knowledge about these bad acts. There are actual lawsuits. Doesn't the fact that one could see reasonably that an attorney might want to point to the existence of a filing, a federal filing, to in fact impress upon the judge that these are not fly-by-night assertions, mere speculations, or someone who's just said something without risking perhaps sanctions.
Defense counsel needed to do more. He needed to talk about what the specific allegations may have been.
Okay, so why was it, you said before, no, these are mere assertions, but when I gave you my hypothetical, you said, that sounds fine, now we've got to get to the prejudice prong. What's the difference between what I described and what you say is deficient in these lawsuits, in the allegations?
Because what the lawyer...
I only gave you allegations, right?
I understand. What the lawyer wanted to ask here was simply about a pending lawsuit. He wanted to say, were you involved in the arrest of Joseph Lagalisi? And if so, isn't it true that you made an arrest and you said Mr. Lagalisi was guilty of a drug sale and yet the cases were later dropped? Isn't that a fact? But he doesn't go and...
Well, could he ask, were you involved in the arrest?
Without
Why can he ask that?
Could he ask if he were involved in the arrest of this person?
Correct.
Perhaps, but it's still subject to the probative value prejudice test, and I'm not sure that just asking that is going to be sufficient.
Well, how does counsel get to the point where he can ask specific questions about a particular scenario or incident without at least setting some kind of context, like this was an arrest? I'm just unclear. Is counsel supposed to just say something like, is it a fact that you mistreated somebody named, or you severely restricted the rights of somebody named Lagalisi? I'm not clear how one would get into that without saying, giving some kind of context or background for the questions.
Well, let's take an easier example. Let's assume there was a federal complaint pending that said the plaintiff in the federal lawsuit had observed Officer Jones steal property from the plaintiff on such and such a date and such a time when he was arresting him. That's a specific allegation of an officer who was testifying at the time. Obviously, a theft is something that goes to the credibility of the officer, and there's a specific allegation of conduct, as opposed to what's in these federal documents that they proffer only on appeal and never to the second, on the second trial, by the way, never to the second judge. These are only general allegations of misconduct by a group of officers. They don't name, with one minor exception, the two officers who testified here at all. This lawyer had to do a little bit more research and come up with more specific allegations against these officers before he could be allowed to ask these questions.
Wouldn't that have been, it strikes me that would have been nice coming from the trial judge, but she didn't do that. She cut him off at every turn. And I didn't think it was a bad point to say, I understand, that the city paid $50,000 for something involving this, and we never, the record doesn't clarify it for us because she says that's simply nothing that goes to the officer's credibility.
Well, and I take issue with what defense counsel argued earlier, which is that the interpretation of this record means that the judge thought these allegations did not go to credibility.
No, my question to you was, wouldn't it have been nice if the judge was making the arguments that you're now making, which would have given the defense lawyer an opportunity to address those things?
Well, I'm not sure the judge needs to do the job of the defense attorney for him.
No, you're not doing the job of the defense attorney. You're doing the job, of the judge here and saying this was not made clear to her. And what I'm suggesting is, wouldn't it have been nice if she had said, you're not making it clear to me.
Okay. I do want to make clear, though, that the credibility, which she thought wasn't going to the officer's credibility, was just the piece about the $50,000. It wasn't that there could be specific allegations that might affect the
Ms.
officer's
Curran,
credibility.
notwithstanding the fact that your light is on, I'm going to take a moment and ask you a question. You, with respect to the second trial,
Yes.
were these issues raised at the second trial?
No.
Was it the same judge?
No.
How does that impact your argument here today, if it does at all?
Well, it doesn't impact our argument. It means that none of the defense arguments are preserved for the second trial at all. They never raised the proposed line of questioning about civil lawsuits at the second trial. There's nothing about federal documents at the second trial. They argue that the court should take judicial notice of the federal documents, but it would be particularly unfair in this instance if the court would do that, because the court is asked to decide whether the trial court exercised appropriate discretion, and because the argument was never made to the second judge and no federal documents were ever shown to the second judge, that evaluation would not be a fair evaluation.
Thank you, Ms. Curran.
Thank you very much.
Ms. Flores?
Just going back briefly to Judge Rivera's question about what would have happened if these lawsuits had a gag order. In that situation, there would have been a countervailing state interest to think about protecting someone's privacy, perhaps, or the privacy of the officers, the privacy of the plaintiffs. And respondent talks about the prejudicial versus probative analysis here, but it's not really appropriate in this case with respect to witnesses who are not the defendant. There was nothing to protect here, no one's privacy. These are public lawsuits. These are not like the police personnel records at issue.
But isn't that something that a judge has to consider in every evidentiary ruling in a trial?
The prejudicial versus probative?
Yeah.
Yes, and it comes into it, but in a different context. Here,
Defendant gets a little more leeway.
Absolutely, and it's a much more appropriate analysis when we're talking about the prejudice to the defendant, because the prejudice to the defendant is he could be improperly convicted based on propensity evidence or something like that. But here, it's hard to articulate what would be the prejudice to these officers or to the people.
Well, confusing the jury.
Exactly, and that is the appropriate analysis, Your Honor. The court had the leeway to not confuse the jury, to not mislead the jury, to not distract from the issues at hand. But here, credibility was a relevant issue. It was a main issue, and it was the centerpiece of defense counsel's strategy. So
The preservation of the second trial.
So defense counsel was so shut down at the first trial. He was told essentially these are not legally relevant, these lawsuits. It was not even a discretionary ruling. It was a legal ruling. And so it would have been futile for defense counsel
But what's he got to lose? A new judge. New judge, new day.
He may have asked again, and
Point of a second trial, if not a new opportunity.
correct, and he certainly could have asked. We're not arguing that he couldn't have, but he didn't need to preserve the issue for appeal because he got a definitive legal ruling at the first trial. He didn't have any new law to rely on at the second trial that would have supported his argument the second time around.
How is a definitive legal ruling of relevance or not before a trial judge who has one set of facts before her or him, binding on essentially another judge of coordinate jurisdiction? I don't see that, counsel.
Certainly, defense counsel could have asked, but it was made futile for him because he was told this is legally irrelevant, this is not going to happen, and he doesn't have an appellate division decision to point to. He doesn't have anything else. He's had one trial.
You know, if you got a new trial, it's a new game. You can introduce the same evidence, different evidence, anything.
Yes, and he certainly could have asked, but he didn't, and all we're arguing is that his request at the first trial was sufficient to preserve it for appellate review at the second trial. Thank you, Your Honor.
Thank you. Next matter is number 110, People versus Tyrell Ingram.
Good afternoon, Your Honors. My name is Elsa Mitoglu. I'm from the Cardozo Criminal Appeals Clinic, and I'm representing the appellant Tyrell Ingram. And I request 2 minutes for rebuttal, please.
You may have your 2 minutes.
Thank you. So the issue in this case, just like in the previous case of Charles Smith, is the same, is whether the court abused its discretion by entirely prohibiting the defense from cross-examining key prosecution witnesses about their prior bad acts alleged in the federal civil rights
And the
lawsuit.
question posed was?
The unfortunate first question posed was, have you ever been sued? And as Judge Rivera noted in the last case, it was only the start. It was supposed to be only the start of the questioning. And again, even though it was unfortunate, it was only the first question, and as a way of laying foundation or showing the presence of good faith.
And how was the attorney prevented from?
The prosecution objected immediately to the question, and then the court basically requested time to review case law and discuss it more. Then the defense lawyer presented the case law, which, by the way, was all about prior bad acts. It was not just about the mere fact of the lawsuit or the mere fact of the existence of the lawsuit. It was all of the cases that she cited in her argument were about prior bad acts.
But did they make a proffer, did the defense counsel make a proffer of specific bad acts from these lawsuits that they wanted to ask about?
We say yes.
Where is that?
The specific bad acts were the acts on where the defense counsel said that the victim who made the lawsuit, Marcus Reyes, was struck in his body in his back 3 times, was unnecessarily tightly handcuffed and strip searched. So those are all specific acts.
So those were the acts that they proffered and that we're reviewing for an abuse of discretion that were excluded?
Yes.
All on the excessive force issue you just described?
Excessive force, and I mean, it's not part of the record because the defense counsel didn't continue speaking, wasn't allowed to continue speaking about the...
But the defense counsel here had overnight to make this record, right? It isn't absolutely not, and we have a page. It's come back tomorrow with your cases.
Yes.
So I think I have a little trouble getting how he was cut off from making that record.
Well, she wasn't cut. I didn't mean to suggest she was cut off. I mean, she did make a record by citing the 4 cases that I just referred to, which were the cases of People v. Marced, People v. Santos, People v. Gissendanner, and I think the third one was People v. Hoodie. And those cases were all about the prior bad act. So as far as...
But that's not usually enough, right? To get up and just say, on the strength of X case and not explain exactly what your proffer is.
You're
or even for an objection, right?
You're totally right, Your Honor. But the defense counsel did explain how the cases were important to her theory of the case, that they went to the credibility of the cops. They then also that they went to her theory of the case.
Did she tie that specifically to this case?
Yes.
How did she do that?
She said that I think this goes directly to the theory of the case, that they are rogue cops. And that sentence was right.
That's specific enough, that they are rogue cops?
Well, it especially tied with read contextually with also her saying that it went to their credibility. Yes, I would say so. And then also each explanation of each case and of how that tied to both of those points.
I'm sorry, so just to clarify, you're not suggesting that the allegations in the cases are the same allegations that the defendant was making, or are you? About what is rogue about these cops?
The allegations you mean in the cases she cited or in the complaint?
Both.
In the cases she cited, no. She was only saying that, look, here, these prior bad acts were found out, and these were good faith basis, and they went to the credibility, and the credibility was a material issue, and it was allowed, so we should do the same here. In terms of the complaint, the acts alleged, the prior bad acts alleged in the lawsuit against the police officers were very similar to the ones that could have also happened in this case.
And all of these police officers were involved in those lawsuits?
All of them. All of them. Yes, so, since it was standard, I mean, this was a standard impeachment of credibility. There was good faith basis given in the lawsuits that are federal civil rights lawsuits that are attested to by the lawyer who is bound by ethical obligations not to lie, who is bound by legal obligations to not file frivolous lawsuits, to investigate and make sure there's reasonable basis to file the lawsuit. So there was good faith basis in them, and even in comparison to a case like People v. Alamo, the good faith basis there, we argue, is much less than the good faith basis found in these lawsuits. So since it was standard impeachment of credibility of key prosecution witnesses in a case where credibility was the key issue, there was nothing else tying the defendant, appellant, Mr. Ingram, to the gun, and there was nothing else except the testimony of those police officers. And defense counsel attempted to question Sergeant Deavy, who was the key prosecution witness, and I think Officer Sanchez, also key prosecution witness for the story of the prosecution against Mr. Ingram. So since there was good enough faith basis, credibility was a key issue, these were key prosecution witnesses. They're not defendant witnesses, so there's not the extra protections that all of the defendant witnesses are supposed to get. There shouldn't have been any basis to completely exclude cross-examination into these.
If the cases are pending and they make some statement in this lawsuit, aren't they perhaps prejudiced in those other lawsuits? I mean, in the defendant's criminal case, aren't they perhaps prejudiced in their civil lawsuits?
Can you, in what way?
Well, let's say the judge lets defense counsel ask a series of questions. Is it possible that that officer, depending on the answer or a failure to answer, might indeed put him or herself in a less than positive position for the civil lawsuits if they're pending?
I suppose so, yes, but...
And if so, is that a factor for the judge to consider in determining whether or not to permit the questioning?
Absolutely, but to permit the questioning entirely, or to permit the questioning, to limit the nature and the extent of the cross-examination?
Yes, if your question is basically reading the allegation in the lawsuit, which, if there's been an answer, the officer's counsel would have already presumably denied, or there's some explanation anyway, if indeed an answer aligns with any statement that's already been made in the civil lawsuit. I get your point. I guess what I'm asking is, let's assume there is some line of questioning that is permissible, that there would be a rule crafted, potentially, that permits this line of questioning. Is it an appropriate factor under potentially such a rule, as you have suggested, where a court should also consider the potential adverse consequences or impact on the officer, the witness who's testifying, as a defendant in this lawsuit? Because you're arguing the witness is not a defendant, so there's nothing prejudicial that will befall that witness in being asked these questions.
Well, I am arguing that...
They're not, right? They're not the defendant in a criminal prosecution.
Exactly, and certainly not in this criminal prosecution. And again, if the balance, if you consider the balance of the factor affecting the police officer in his civil rights lawsuit versus the freedom of the defendant in this criminal action, then, I mean, still the balance.
Although who knows, it might inculpate him, right? Depending, or her, depending on the conduct in a criminal act. Is that not possible?
I'm sorry, say that again?
In a criminal act, is that not possible? The officer may have done something that's alleged in that civil action that has the possibility of suggesting as a criminal actions involved?
Yes, that could be the case, but still, I think, as by Counsel Claudia Flores suggested, is that it would still be useful to the jury to observe the demeanor of the police officer being asked at least a or two questions about it.
Okay.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. May it please the Court. Raffaelina Gianfrancesco on behalf of James A. McCarty, appointed Special Acting District Attorney for Bronx County in this matter. Although provided ample opportunity to do so, defense counsel failed to suggest to the trial court in this case that she wished to ask the police officers about any facts, and specifically any facts that are alleged with regard to these officers in the underlying lawsuit.
If she had, would they have been admissible then?
Excuse me, Your Honor?
If she'd done what you had just said she failed to do, would that evidence then be admissible?
If she had done that, then she would have laid the good faith basis and a reasonable basis in fact.
When
and
she
then,
asked whether or she said that the lawsuit was evidence of prior bad acts, can't we infer that she was going to ask about those acts?
Absolutely not, Your Honor. I know defense counsel suggests that by presenting the court with cases that weren't actually even on point with regard to this issue, that the inference was there. This record fully supports the appellate division's decision that the defense counsel never asked, though given plenty of opportunity. The prosecutor several times in this case when they were discussing, when she sua sponte started asking that question and it was immediately objected to and sustained, the prosecutor says the fact of being sued is not permissible impeachment material.
I disagree. I think that's funny that we've said that several times now. Now, if there's a good faith basis, if somebody's been sued and they settled the case admitting that they were wrong, there's nothing wrong with asking, have you been sued? Because the next thing coming up is yes, and then you can get into the facts. So this isn't some big red light in courts that say, you can never ask if anybody's been sued. So I'm not sure that's the appropriate approach here. And what I asked you before, and I was wondering if you could tell me, are there circumstances under which prior police bad acts can be introduced in a case such as these to impeach the testimony of an arresting officer?
Yes, Judge Piggott.
And what would, in your view, be the foundation upon which you could do that?
Okay, I know you're using the word foundation to lay that for the evidentiary admissibility of that. But if we're looking at it in terms of what is the standard here for anyone, either a prosecutor or a defense counsel, to impeach a witness, it is there a good faith basis and a reasonable basis in fact? So where do we look at first? We look at what is the source of information.
No. Let's keep going. You said, all right, there has to be a good faith basis.
Correct.
All right, so let's assume they have a good faith basis.
Okay, so they have the good faith basis. Then we go to the next step, and we have the trial court weigh what those questions are, or what are the underlying...
Why? I mean, I've got a good faith basis. I say, have you been sued? The people object, overruled. And because I said, Judge, I've got a good faith basis for this. The next question is, answer that question. Yes, I have. All right, and were you sued for police brutality on a certain date? No. End of inquiry. Yes, I was. Tell us about it. It's a false accusation. It was made against me because of this, that, and the other thing. Let's move on. But the idea that you can't even get there is what troubles me.
Okay, Judge, well, I would equate that to the question of have you in fact been sued is similar to the question have you ever been arrested or are you under indictment? This court has not allowed those questions. In People v. Miller, this court has said you cannot ask someone if they've been arrested.
Can you go right to the underlying acts?
Exactly. If you lay that good faith basis, Your Honor.
What's the good faith basis? How do you get there?
The good faith basis is, do you have a reliable source of information? And this court held in...
But wait a minute. You're outside the presence of the jury. Forget about the inartful question, have you ever been sued? Because I agree with you there. Right. It's an inartful question. I think even the opposing side would agree with that. But nonetheless, you come into court, you have papers that say Officer X is being sued with a series of factual allegations against a series of officers. The judge says, do you have a good faith basis? Yes, I do, Your Honor. I have all the papers here that make allegations against them. I want to ask them about those allegations. Now, whether the question's phrased, can you be sued or not, isn't the mere production of the documents sufficient not to establish a foundation, but to establish a good faith basis for your questions and cross-examination?
Your Honor, I would put it as a two-pronged requirement. Mm-hmm. It is, where's your source of information? So I'm coming in with
all
this...
right, I tell you. No, slow down. So I tell you, it's right here, Judge. It's
okay.
Federal number, whatever. You can get them off the Internet. We all can.
Which is, I presume, is what happened in this case, even though defense counsel doesn't even note to the court that she has this information from Pacer or actually even has the lawsuit with her. So she brings in the lawsuit. But then you have to ask the next question. What are the specific bad acts that you now allege?
All right, now let's take that. What you're saying is you have to vet each question, it sounds like to me, in cross-examination. And I don't think that's ever been the rule on cross-examination, that you have to vet each question ahead of time before you can ask it. There are rare circumstances where it does happen, but specifically this vetting of questions, of course, if I'm the people in this instance, I would always want that because then I have heard the question ahead of time and the answers can then be anticipated if you're the witness or you're the people out there. But that totally undermines the purpose of cross-examination.
I agree.
Your proposed rule totally undermines the purpose of cross-examination and creates a situation where cross-examination is effectively negated. Its effectiveness is destroyed.
I understand what's troubling you, Judge. Right, there is no rule. We're not requiring a motion in limine for the defense in order to ask these questions. However, when you're approaching it the way the defense attorney did in this case, and the question is, have you ever been sued, of course that's going to prompt an objection by the people and a sidebar.
Perhaps a justifiable objection.
Correct. So, and I think this was, the court properly sustained the objection in this case.
Assuming the judge wouldn't allow the questions, but the trial went on, and then defense counsel, without doing the vetting, asked a specific question about misconduct. So you're saying the judge might not have allowed that question because it wasn't vetted by, saying I have a good faith basis? I'm sure that the prosecution would have objected.
Correct, yeah.
And then defense counsel would have said, here's my good faith basis.
Right.
I have these lawsuits.
Yes,
Right?
Judge, and I think that's the way it would have been handled. What I'm trying to say is that it's not that the question can't be asked. It's not that the defense counsel must come to the court, though in the other two cases, there was opportunity for all the parties to engage in this conversation with regard to what the allegations are and where they're coming from. That's never been a requirement for cross-examination.
So what would you think is the rule? I think you agree that under certain circumstances, a police officer can be cross-examined like any other witness, including prior bad acts.
Absolutely.
Okay. What's the rule that you would apply in these cases?
I would apply the rule that has always been applied, that seems to always been applied by all fourth departments in this court. Have you presented a good faith basis and a reasonable basis in fact, and are you requesting to ask questions with regard to specific allegations which would allow the jury to make a determination with regard to this witness's credibility? And that's not what occurred in this case. Defense counsel, when they were vetting this after the objection was made, was given every opportunity to present what she would have believed to have been specific prior bad acts committed by Detective Sanchez, who was on the stand at the time. The only thing that she told the court was that this lawsuit is indication of a prior bad act. It's not. We know that. The same way an arrest or an indictment is not indication of...
How do we know that?
Because the courts have told us. The mere fact that you've been arrested or under indictment...
No, I understand that. I'm still not giving up on you. You can ask if somebody's been sued. But the fact of the matter, let's assume for a minute that he bopped somebody over the head and he got sued for it. Have you been sued? Yes. And isn't it a fact that you were sued because you bopped somebody over the head? Yes. Did you bop somebody over the head? No.
I understand you're troubled by the question of have you been sued, but that is not what the...
I'm not. I just want to get rid of that. Here's my point. You have a right as a prosecutor to say if the defendant takes the stand, I can ask him about prior bad acts, and I intend to. Can the defense do the same thing?
No. The defense actually, the prosecutor has a higher burden. We have to have a Sandoval ruling. We have to inquire beforehand.
I'm not suggesting Sandoval. I'm suggesting Ventimiglia. I'm saying that if you've got prior bad acts of the defense, or the defendant, you can question him about that. Now, the judge may want to know what they are,
Right.
But I think it's the same thing here. I'm going to fully intend to ask him about the fact that he's been sued in federal court 15 times.
But not the fact that you've just been sued, Judge. You have to also look at the specific bad acts, because what you're asking a jury...
Do you understand what I'm saying? Mm-hmm. The answer to that is, of course. But you can't say, you can't ask if he's been sued, because if you can't ask that, then how are you going to get over here? I'm saying, everybody says, you can say, have you been sued? You've got to have a good faith basis to ask that. And the answer has got to be yes. You can't say, have you been sued, and not know the answer. So then you go into what you now want to say. You have to get specific. Right. I guess that's all I'm fencing.
Okay, that's fine.
Counsel, in the mechanics,
okay.
I'm sorry. In the mechanics, is it what you're saying that the first question is not have you been sued, but you've got to get to the facts? And when you or another prosecutor stands up and says, I object, that at that point, if defense counsel hasn't already done it, has to then say, this is my source. So now let's get to the real here. So my source, do you agree that an existing or prior lawsuit can provide a good faith basis for these questions?
Yes.
So you don't object to the fact that the source is a lawsuit?
No. It is that's a fine source. If it's a lawsuit that's been filed, then you have to go...
What if it's been settled?
Well, if it's been settled, I would say That's something that the court could look at. Depends on, is it settled, is it dismissed? Is it dismissed on the merits? Have there been no admissions of guilt by the officers?
More likely than not going to get that in a settlement, but if there's no admissions of guilt, how is that any different from it's a pending lawsuit and we haven't worked out, we haven't yet figured out whether or not, in fact, I won't say guilt, liability, right? The defendant is liable.
Right. I think it's just one thing that I would assume that if it's for the prosecutor, in their respect, they're going to raise it to the court. I think it's just part of the whole question of whether or not the cross-examination. But in this case, it's clear on this record that the defendant was never precluded from asking about the underlying facts. Thank you.
Thank you. Counsel?
I would just like to address the argument that there was no good faith basis because of the lack of specific factual allegations. As Ms. Garcia asked before, this is on page 12 of our opening brief, and onwards we cite the entirety of the record where...
Are those allegations, though, against this Detective Sanchez? I mean, he said the proffer is that there were this excessive force used to show there were rogue cops, but is there any indication that the specific allegations here go to the witness who's actually testifying?
Well, our argument for that would be that, again, like Judge Biggert suggested, you could still just ask about them, and the witness can try to, can answer and specify, no, I wasn't involved.
Then I think you've got a good faith basis problem. Like, to go to Judge Rivera's point, let's say you have a gun case, right, and there's a gun on the floor, they arrest somebody, it's dismissed, that defendant brings a future civil rights suit. Same cop arrests a defendant, gun possession, similar circumstances. You want to come in and you want to say, did you arrest so-and-so? Didn't you claim there was a gun on the floor? Wasn't that full? And objection, good faith basis, there's this lawsuit. I think we all agree that's fine. But what you're doing here is saying there's a general lawsuit, I guess, against a group. There's some excessive force allegation, but you've got one detective on the stand you want to cross about that. So where's your good faith basis for asking this witness, did you strike someone in the back, did you strike him in the body? I mean, putting aside the relevance to the issues in this case.
Well, we don't see any difference between the scenario that you just described and what happened here. I mean, you could have one police officer committing bad acts on his own, and you could have 8 police officers committing bad acts as a group. And 2 of them could be beating, 2 of them could be watching, 2 of them could be lying. It's not, and all of these bad acts individually and together are prior bad acts together. And in People v. Alamo, for example, the good faith basis there was, it was just merely the information that was given to the prosecution by a police officer that the defendant was merely in a room with 2 other people and some keys from stolen taxes. We don't see how that's less, or more good faith basis than the one that exists here.
I'm sorry. Are you saying, given the nature of the work of an officer, that even not acting when there is certain bad conduct by a group of officers is enough to ask about? I'm observing the other officers beat up someone.
And I'm
an officer, I do nothing, and I don't report it later.
Yes, we would consider that that's a prior bad act.
But would you then consider that person watching a rogue cop?
Well, if part of your not being a rogue cop is reporting other rogue cops, then not doing so is being a rogue cop.
Thank you, counsel.
Thank you.
Next is 111, People versus Isma McGhee.
Good afternoon. Mark Zeno for Appellant Isma McGhee. I'd like to reserve 2 minutes for rebuttal.
Certainly, sir.
What distinguishes this case from the prior two is the state of counsel's application. Counsel specifically did not want to ask about the fact that a lawsuit was filed or a lawsuit was settled. He wanted to ask about the underlying facts of the lawsuit themselves. He wanted to ask the right question, were you involved in false arrests? And the facts underlying those false arrests. The court found that that was irrelevant. The court found that the defense counsel had established a good faith basis for those questions, but that they were irrelevant.
Well, isn't there another distinction here which is a little bit more problematic, which is that the witness in question was not the person that had conducted the arrest or the buys or anything. It was somebody who was supervising other judges, other police.
They did present Detective Rivera as the supervising officer of the operation at the Lincoln houses. They chose to present him not only as the supervising officer, but as the officer through whom they explained their case. He was the lead detective in the case. He was the most important witness. There were other witnesses who performed the underlying buys, but he was the lead detective.
What were the specific allegations that were to be raised?
Well, counsel said that there were 3 lawsuits that he wanted to ask about, 2 of which had been settled, one for $75,000, I think, and one for $20,000. And he wanted to ask about the underlying facts of those lawsuits.
Does it matter that Detective Rivera was not one of the people involved in the buy and bust, but was supervising the operation?
No, it doesn't matter. Perhaps in terms of harm, it might matter, whether it was harmless error to have precluded the questioning, but it certainly didn't matter in terms of the defendant's right to impeach him. A defendant has a right to impeach adverse witnesses. The Confrontation Clause guarantees him that right. He has a right to...
There has to be a probative value to it, and the court gets to weigh how removed it is from what this particular witness meant in this particular case. So doesn't the court have some leeway there?
The court does have some leeway. That's not the basis on which the court precluded the questioning here. The court found it was irrelevant. It didn't find as a matter of discretion that the questioning shouldn't happen because he was only a secondary witness. I would say that...
Why isn't that subsumed under it's irrelevant?
Relevance is a legal determination. It's not... If something is relevant, it is admissible unless there's an exclusionary rule to preclude it. Once it's found to be relevant, then the court has to weigh prejudice versus probative value. But the court never got there. The court found here that it was irrelevant because the allegations hadn't been proven yet, that the lawsuit alone wasn't enough to establish its relevance, and that's clearly not the case. The lawsuit didn't have to be proven. The defendant didn't have to win the lawsuit alone.
Let's say we were to agree with you. Why isn't it harmless?
Why isn't it harmless? Getting back to, again, the people chose to present Detective Rivera as the lead witness. He was the narrator of the people's case. If the defendant had been able to establish that he was a liar, that his testimony shouldn't be believed, then the jury might well have disregarded all the testimony. He was supervising the operation.
Yeah, but maybe that's true, but there were several buys here made by different undercover officers who testified to those direct buys. So assuming Detective Rivera was a supervisor and he laid out, what the overall operation was, don't you still have overwhelming evidence of the defendant's guilt of the buys?
No.
Through the undercover detectives who actually participated in them?
No. Notwithstanding the fact that there were, I think, 10 alleged buys, there was no buy money recovered. There were no audio tapes, videotapes, fingerprints. They executed a search warrant in my client's apartment. There was nothing there to suggest he was involved in drug dealing.
It's a significant leap that you're making there, that a jury, if it were to agree that, or conclude that Rivera is just not trustworthy, given the lawsuits, that therefore every other officer who gets up is not trustworthy.
The question is, under Crimmins, is there assuming even if there's overwhelming evidence, you have to go to the next step. If the questioning had been allowed and the defense had been successful in establishing that Officer Rivera was not credible, would that have affected the verdict? Is there a reasonable possibility that it affected the verdict? And if the people's lead witness is attacked and proven to be a liar, I say...
Did they call him the lead witness?
Did they call him the lead witness?
Did they present him as the case turns on this person?
No, they did not use those. Those are my words, Your Honor. He was the narrator of the people's case. He collected all of the evidence. He supervised the evidence as the buy operation unfolded, and he presented the case to the jury. He was the person through whom the case was comprised. So there's just, if he had been shown to be incredible, there's no way a jury would have disregarded that and found the people had proven their case.
Mr. Zeno, you've raised a second issue, I believe, on the propriety of the defendant's sentence. You want to spend a little bit of time on that?
Sure, Your Honor. The defendant was sentenced as a second felony drug offender whose prior conviction was a violent felony on the basis of a third-degree criminal possession of a weapon conviction. The statute, 70.70 and 70.02, at the time that the defendant committed this crime, did not list CPW 3 under subdivision 4 as a violent felony, and for that reason, it did not give defendant fair notice of the penalty that he would face. If the defendant looked at the statutes at the time he was committed this crime and wanted to determine the sentence he would receive, he would not have found under 70.02 the conviction under CBW 3 subdivision 4, and it would be unfair to sentence him to a sentence which he did not receive fair notice of.
There was also the question of the photo array.
That's right, Your Honor. The photo array, which, taking a step back, the officer who viewed the photo array 2 months after the crime had provided a description of the perpetrator as having one eye that's kind of off.
I looked at that photo array, and I can't really even see there's nothing that stands out to me about his eye. I mean, maybe he's looking in a slightly different direction or something, but I'm not sure.
It doesn't appear to be exaggerated. I agree with the judge. I looked at it too.
I'm not sure what makes it suggestive.
Well, what makes it suggestive is, again, if you look at the photo, there are 5 men who are staring directly at the camera, and there's one who's looking off up to the right, I believe.
Yeah, maybe a little bit. Yeah.
With one eye looking even more further to the right.
You know, it's looking at the photo array made me think of how would one identify Mike Tyson, somebody with a facial tattoo, say? It's that kind of situation, and it doesn't seem like there's a practical way to cover up part of somebody's tattoo and still go through a normal identifying process. I suppose 20 years from now, when judges all have tattoos, it'll be more of a common problem. But at this point in our jurisprudence, we haven't reached that level, thank God, yet. So, but it will become a problem, I think, where facial identifying characteristics will not be able to be covered up or be made so standardized. But in this point, I'm not sure how you say the medical condition strabismus. Is that it? You know,
can you repeat that?
Strabismus, is that the medical condition?
I'm not sure. I would call it a walleye.
I see.
I think that I see my time is up, but just 2 quick reactions to that, Your Honor. One, I think you have to look at the fact that the witness identified the perpetrator in their description, one eye that's kind of off. Mm-hmm. So there were 5 people who unquestionably in the array did not have one eye that's kind of off.
So what efforts do the police or prosecutor have to make
well, it's a photo array.
Everyone has to have an off eye?
And not at all. It's a photo array, Your Honor. They could have just put a piece of paper over the offending eye on each of the photos in the array, and that would have eliminated the suggestiveness. Very simple.
Thank you, counsel.
Thanks.
Good afternoon, Your Honors. My name is Sylvia Wertheimer. I represent the people. I'd like to focus on the fact that the proffer here was really very general. The problem in this case...
Counsel, just to go to the proffer, and we've been talking a lot about what specific proffers were made, and I think this case is somewhat different in that defense counsel here showed a good faith basis for why they wanted to ask this, the lawsuits, but then pointed to specific acts they wanted to ask about, and saying, look, I understand the suit itself would be irrelevant, but that gives me a good faith basis to ask if he participated in some of the acts that allegedly would fall into the bad and malicious acts. Why doesn't that get you to these bad acts, which then there is some proffer as to what they would be?
Well, I would submit that there is no proffer as to what the bad acts would be. I think a key point is that the federal lawsuits alleged group misconduct, and the rationale behind bad act impeachment is that the bad act has to be probative and tend to show that the witness is untrustworthy or willing to put his own interests above the interests of others. It's not enough to just say it's a bad act.
But he says it's false arrest,
Well,
right?
a false arrest is not first of all, the question didn't necessarily, in terms he said, did you want to arrest people who committed, were you involved in the arrest of people who committed no crimes? That doesn't necessarily even mean there wasn't probable cause. But even if there was, we're contemplating an arrest without probable cause, being involved, what does that mean? As Justice Rivera said, what if he just was watching somebody else arrest? It matters what this particular police officer did.
But he could say that. I mean, the questions he wants to ask are, so I was going to ask him if he's aware of being involved in the arrest of so-and-so, this plaintiff, if such an arrest took place on the dates that were alleged, and is it in fact that those plaintiffs committed no crimes and he participated in a false arrest? Why doesn't that give you the basis to ask that question?
Because that doesn't show that this particular detective, the witness on the stand, did anything wrong. It's involved an allegation of a group of officers.
Who made a false arrest?
A group of officers who arrested somebody who didn't commit a crime. Now, if you arrest somebody without probable cause, first of all, you don't know what this particular detective's role was. The lawsuits were not made part of the record. But I believe in one of the cases, for example, what if the officer just swore out a complaint based on what the other officers who were on the scene said to him? Would that be a bad act by this officer? We submit it wouldn't be. Probable cause is a very complicated concept. Police officers can make mistakes. Simply arresting somebody without probable cause does not tend to show that the detective is untrustworthy.
Counsel, are we slicing this issue of bad acts and immoral conduct or other things very thin because these are police officers? Or wouldn't this be the case with any other witness, that people make mistakes and they do things that they can explain if they're asked about?
Okay, but we submit that it's not a different rule for police officers because you couldn't ask a witness about something that they did as a group. I mean, would you be able to ask a witness, a defendant or any other witness, were you present at a club when the group of people you were with fired shots at somebody else? Wouldn't you have to first have a basis that this particular witness fired some shots and was involved? The fact that he was just part of the group, that wouldn't be a proper basis for this particular witness having committed a bad act. In addition, it certainly
But that might be the first question leading to the questions that are connected to that bad act. Is defense counsel not able to do that?
Well, the defense counsel could have made a proffer as to what this particular officer did. He chose not to do so. I submit
Counsel, of the underlying cases, if the criminal case is dismissed, that's forming the basis of these allegations?
Yes, they were dismissed. I think they were quickly dismissed. None of this is in the record, by the way.
So let me ask you a question. How would defense counsel get to any possible specific acts? Would they have access to the case file from the underlying criminal case? Would they have access to the personnel file of the police officer who may have been involved in the false arrest?
No, I believe what they would have access to is documents relating to the federal lawsuit. They could call up the attorney who represents the plaintiff in the federal lawsuit and say, get more information.
The criminal case file?
No, I don't think you would have access to the criminal case file, but this is based on the allegations from the federal lawsuit. So you could call up the lawyer who's representing the plaintiff in the federal lawsuit and say, what did this particular witness supposedly do? And
He knew he would have put it in the lawsuit, right?
Excuse me?
Well, he knew he would have put it in the complaint?
Well, not necessarily, and we don't even know.
So he might not be as
We don't even know in this case. I believe that, the defense counsel here could have been particularly vague.
Well, wouldn't you be arguing, too, that it wasn't a good faith basis? So counsel for the plaintiff told you that this is it? I mean, it's not in a pleading.
No, not if it's, not if we wouldn't, I don't think so. If it was based on the counsel, these are the allegations underlying federal false arrest allegations in a lawsuit. But certainly also it goes to the exercise.
I don't understand that argument. Look, I'm an attorney. I represent someone who claims an officer committed a bad act that violated my civil rights. The attorney does research, decides, yes, there's a colorable claim, files it, sets out the allegations to survive the motion to dismiss or not. Why isn't that enough? I've set out in this thing that this group or this individual did not follow the duty of an officer.
We submit that the key point is whether there's a showing of specific factual wrongdoing by this particular officer. And just to say, were you involved in a false arrest is not necessarily relevant of credibility.
But that's not what the judge ruled. I mean, that would be an interesting ruling, but the court ruled, I know you say it's part of your defense, I suppose, that he was falsely arrested, but how is the relevance of another case claiming false arrest against this police officer a viable question, really? Nothing has been proven that he indeed falsely arrested someone. That seems like the wrong standard for evaluating whether or not you can ask the question.
Well, number one, I don't think the nothing has been proven is the sole basis of, that was one of the things that the court said. The court is thinking, in response. I think the first part is that how is it...
Because we're bound by the proffer, aren't we bound by the ruling?
Well, the proffer is how, and the ruling was, how is it relevant? And it's not relevant unless you show that there's something that indicates that this, that the conduct that this particular officer committed in this situation tends to show he was untrustworthy. What if he was just standing there?
So, counsel, let's say we don't agree with your interpretation of this record, and Judge Garcia wins the day in his interpretation of the record. Is it enough, then? Did the judge make an error? If that's the correct interpretation, the judge basis on
no, because
mere allegations in a civil rights lawsuit is not enough.
No, the judge went further and exercised the discretion. The colloquy continued after the judge made the comment, how is it relevant? And the prosecutor specifically invoked the exercise of discretion, specifically mentioned that there would be prejudice from this line of questioning. And I think that's something that we're a little bit ignoring, is that there is some aura of prejudice trying to be, there's a potential for confusing the issues, and this whole idea of police conduct, misconduct being a hot topic nowadays, trying to inject that specter into a lawsuit.
Is that the prejudice you're referring to?
Well, that's part of the prejudice, and I think that's part of what the courts are...
So you're saying because there's allegations among police officers that they commit bad acts that we should not be allowed to ask about bad acts?
No, I'm saying that I'm saying not never. I'm saying that that's something that should be taken into account, and when you have minimal probative value, and here there was minimal probative value that you didn't even show.
You say that, but the judge didn't say that. He said it's irrelevant.
No,
it could be probative as heck.
The judge in the end...
I was almost done, but that's okay. Go ahead.
I'm sorry.
That's all right.
The judge in the end said that she was basing her ruling based on everything that has been stated. Everything that has been stated included the prosecutor specifically referring to discretion, specifically referring to prejudice, and specifically referring to the fact that the allegations were vague and didn't allege wrongdoing by this particular...
It was a valiant effort, I think, by the prosecutor, but I take that statement as I am not going to allow it based on what has already been stated to mean what I have already stated, which is it's not relevant.
Well, I would disagree that it should be... I think if that's what the judge meant, she would have just said, based on what I have already stated.
Well, she said, I mean, you have a good faith basis, but it still seems to be irrelevant.
But she said that before she said, I'm ruling based on what has already been stated. That was way before. Then the judge said, how is it relevant? And there was a whole other colloquy. In any event, as certainly any error would be harmless, with respect to if there wasn't, and again, this is an exercise of discretion. I don't think you could really discount the prejudice here when there's no showing of specific
Can you
misconduct by this
just,
police
your light has
officer.
gone off, but just in a couple of sentences, address the photo array?
The photo array, it was a mixed question of law and fact. If you look at the photo array, as the judge said below, and as the appellate division affirmed, the eye condition was not all that noticeable. If you look at the picture, it almost looks like all that's happening is that this defendant is looking off to the side, not necessarily that he has an eye condition. So certainly, in terms of the standard of whether this called for the, was a suggestive and attracted attention to this individual, we would submit not. We submit also, this is, there certainly was appropriate to have a hearing, but this was not just a civilian witness. This was a trained police officer who looked at it carefully, who looked at it for a minute, and certainly was careful with respect to that. I don't know if you want me to say anything about the sentence.
Could you just, a couple of words about that?
Okay, with respect to the sentence, the key point we submit is that the conduct that constituted the prior crime was and continued to be a violent felony at all times. It used to
Notice is a person contemplating a criminal act supposed to go to the penal law and look at all the different crimes that the acts might constitute?
Well, I don't know that a person contemplating an act is going to go and think in terms of the particular section number as opposed to the conduct. The conduct was the same. The conduct is possessing a loaded firearm outside the home or place of business.
But how would a defendant know that conduct was?
Because if you look and you see possession of that is now CPW 2, and that is listed as a violent felony. And in Morse, this court said that fair notice is provided so long as the elements of the crime when committed were the same as the elements of an offense defined as a violent felony at the time the enhanced sentence is imposed. So this continued to be a violent felony. Possession of a loaded firearm outside the home or place of business was always a violent felony. In addition, the language of the statute, the plain statutory language, says it was a violent felony. This defendant had notice at the time that he was convicted. That's when he was convicted, it was a violent felony. So that also gave him notice that he was subjected to enhanced sentencing on the basis that that was a violent felony.
Thank you, counsel.
We ask that the judgment be affirmed. Thank you.
Does the use of the word was a violent felony, affect your argument?
It's relevant to the argument, Your Honor. I would point to different precise language. 70.71b says, violent felony shall have the same meaning as that term is defined in section 70.02 sub 1. And then you turn to 70.02 sub 1, and you do not find this violent felony listed there. The way the legislature set up the violent felony offender sentencing statute is they provided a list of B violent felonies, C violent felonies, D violent felonies, and 265.02 sub 4 is not listed there.
You wouldn't argue that the legislature didn't intend for this to be
I think it was, as we say in our brief, it was a drafting error. There's no question it was a drafting error. That when they made the change to the law and elevated this crime, they didn't realize what they were doing, that they were taking this crime off the list. But they did take this crime off the list, and the defendant would not have fair notice.
They didn't take the underlying acts as a crime off the list.
That the definition, the section number and the name of the crime was taken off the list. It's no longer part of the list. If you were to go to the statute today, you would not find this crime, 265.02 sub 4, listed as a violent felony. I'm sorry?
How does Morse affect the analysis?
Well, Morse used different language. It said it had backward-looking language. It talked in terms of what was a felony, and it was a second felony offender statute. It's a different language than this crime. And this crime says, this statute, 70.70, again, I keep going back to this, 70.71b says, violent felony shall have the same meaning as that term is defined in 70.02. You go to 70.02, and it's not there. So And just, if I could just have one more moment
Please.
to address the cross-examination point. I think that this Court has never required before, if a defendant wants to ask a witness, an adverse witness about prior bad acts, a proffer to prove relevance before asking the question. And that's what the prosecutor is asking for here, that the defendant has to prove relevance before they can even ask the question, that the defendant has to prove that the officer was involved in the underlying conduct in a specific, identifiable way before you can even ask the officer about
Counsel, and I think this case is somewhat different, but wouldn't you agree you have to do something more than proffer there is a lawsuit and this person is named, or there is a lawsuit and it was settled for $1 million? I mean, does that get you the right to ask anything you want about the underlying lawsuit?
If you ask a question about the underlying conduct and the prosecutor objects saying, what's your good faith basis for asking that question, then you may need to provide a more specific answer. I have a lawsuit here. It says that Officer Rivera did these acts.
So what if you just went in and you're cross-examining your witness and you say, did you arrest so-and-so? There's an objection. Didn't this come up in a lot of these cases because the first question out of the box is, are you being sued in a civil rights lawsuit? Or, that's the question that sparks the objection. And isn't that an objectionable question?
Which question? Were you sued or did you arrest
Is there a
so-and-so?
civil rights lawsuit pending against you? Or were you sued or did this case get dismissed? I mean, aren't those the questions that spark this? So if you ask the questions you're saying you'd ask, then the next question would be, hey, what's your good faith basis for asking that, right? Did you arrest so-and-so and there was a gun alleged to be thrown down in that case? Those are objection questions. But when you lead with, you're named as a defendant in a civil rights lawsuit, or I want to, isn't that different?
Well, that's the wrong way to lead, and that's not what the lawyer wanted to ask about here. I think it's perfectly appropriate to lead with the question, did you arrest John Smith on such and such a date on the corner of Eagle and Broadway, and claim in a sworn criminal court complaint that you observed him engaged in a drug transaction. That's a perfectly appropriate lead question for which no proffer in advance is necessary.
Right. And then what's your good faith basis would be it's an allegation in a...
Correct.
Thank you, counsel.
Thank you.